including. Okay, I'm going to briefly announce, since we're finally being recorded, this is the Hellenic Law Society MCLE event, Fraud on the Supreme Court in Korematsu versus United States. Our speaker tonight is San Francisco attorney Dale Minami, and I don't see Dale's, oh, there he is, okay. Dale comes from the firm of Minami and Tamaki LLP in San Francisco. He's received numerous awards, including from the ABA, for his work in this case. I want to add one other side note about Dale. I've been involved in a Rotary project that does cleft lip and palate surgery around the world. And one of our very talented volunteer doctors is Dale's older brother, Roland Minami. And from talking to Dale, Roland was incarcerated as a 1-year-old, I believe. Maybe Dale will tell us more about this. But this is a very, very important case. And without further ado, let's welcome Dale Minami to talk to us.
Well, thank you, Pete. Can you hear me okay?
Yes.
All right. Thank you for the Hellenic Law Society and for Peter to invite me. When I told my brother, he was thrilled because they had gone on a number of trips together to do charitable surgeries for young people in mostly third world countries. Anyways, my job is not to talk about that, but to talk about a case I was involved in many years ago. Like Pete said, when I was a younger attorney, of course, I was a lot younger then. But the story starts in 1941, December 7th, 1941, when the imperial forces of Japan started the war by bombing Pearl Harbor. And as a result of the bombing, Japanese Americans of Japanese ancestry, 2/3 of whom American were citizens, were eventually rounded up, banished from the West Coast, and sent to prisons. They included, like Pete said, my then one-year-old brother, and the justification was military necessity. The crime was racial ancestry because they were taken en masse. It was one of the greatest civil rights disasters in this country's history. The old, the young, whole families, little kids lived in horse stalls like my brother and my parents and grandparents did at Santa Anita near Los Angeles. Feces on the wall, hay on the ground, and had to live there for 6 months before they were then transferred to what were called relocation centers. Well, they were really prisons, and they were set up in the nethermost dismal regions of the United States. The guard towers, they had barbed wire fences, and food was terrible, inadequate medical care. There was loss of privacy because there was no doors to the bathrooms. And perhaps the worst indignity of all was the loss of their American citizenship in a way. They were humiliated, and that shame was perhaps the psychological damage inflicted was worse than almost anything else. The history of this was not unique. Japanese Americans and Japanese inherited a legacy of racism against Asian Americans, starting from the first Chinese who started coming to this country en masse in the 1850s. And they were immediately demonized after a short honeymoon period. And pretty soon movements grew to exclude them from the United States. There were laws passed against them. They couldn't go into certain occupations. They were like the foreign miners tax, for example, which was really aimed at and only enforced against Chinese Americans. Despite their contributions of building the railroads and many other contributions. People like Dr. Seuss, who later recanted his racism, stirred the fire a lot, in fact, along with other politicians that used the Japanese Americans as a stepping stone in a way. My parents were sentenced to indefinite confinement. 2/3 of them were American citizens. They had no constitutional rights to a trial, to a jury, notice of charges, the right to an attorney. They were, again, branded as spies and as saboteurs. It was an amazing set of decisions by the president, who issued Executive Order 9066, which authorized these deprivations. Then the legislature, Congress, had passed laws enforcing the president's order. But 3 men stood up to challenge these military orders, to take away 120,000 Americans from these West Coast states to 10 different prisons around the country. 3 men stood up, and one woman who did not challenge exactly the military orders, but her incarceration. So she has to be included in one of the, when we call heroes now. The first to be tried was Gordon Hirabayashi. He was a Quaker. He was a grad student at the University of Washington, American citizen. He felt that it was his duty to resist these orders. Otherwise, he would be giving up his rights to an American citizenship. He was tried, convicted, sent to he was sent to prison or jail, but he asked his sentence to be extended from 30 days to 90 days, which is probably the only time in history of a convicted person asked for an increased sentence, only because he could realize he could work outside if he had a 90-day sentence. That later came back to haunt him, that decision, because the counts that he was charged with were run concurrently, and that gave an excuse to the Supreme Court. Again, this case is so complex, or this set of cases are so difficult. It takes hours to really unravel them and explicate them and make us understand completely the manipulation that occurred, not just the fraud, but the manipulation of the procedures. In Oregon, Portland, Oregon, a young lawyer named Minya Sui deliberately flouted the curfew orders. He walked around in Portland, tried to get arrested, went to the local gendarme or police and said, look, here's my birth certificate, here's my watch, it's past 8 o'clock, I'm violating the curfew. And the policeman who knew Min and his family said, look, Min, why don't you just go home? You're just going to get in trouble. So undaunted, Min walks down to the central station in Portland, gets arrested. Unfortunately, he wasn't a criminal lawyer because he got arrested on a Friday. And of course, that means that you don't get out until Monday. He was convicted. He spent a year in solitary confinement in jail as part of his punishment. Fred Korematsu was a draftsman a welder in California, San Leandro, very close by. And he didn't have those ideological reasons like Min did about the Constitution or Gordon about waiving his rights. Fred was in love, and he did have this really strong sense of righteousness, though, because his rationale was really, hey, wait a minute, why should I go? And no one else is going. I'm being punished for being Japanese. And so he hid out. He had minor plastic surgery, but they caught him and they put him in Topaz or Tanforan, which, by the way, just reopened as a memorial site or memorial site for the racetrack that was there, where Japanese Americans were also housed in these horse stalls. And just last week they had a ceremony down there, and there's still an exhibit there going on. They brought their cases to the Supreme Court, all 3 of them separately, and they were broken up in the sense they wanted a unanimous decision. And Fred was alleging the most critical of the rights violations, which was detention. And the court didn't want to deal with that, so it dealt with Minyasui and Gordon Iribayashi first. It upheld their decision. This is Mitsui Endo, by the way, who challenged much later her confinement. But the court had a problem, and the problem was it had no evidence that Japanese Americans were dangerous, that there was a military necessity. There was no acts of espionage or sabotage ever proven against the Japanese or Japanese American. And as a result, the government had to virtually manufacture a rationale and manufacture a record for that matter. And so in Hirabayashi, which became the first case that established the judicial precedent, the court had to advert to these peripheral facts. They were not facts that, oh, these Japanese committed espionage. Oh, we found a cluster of spies somewhere. What they did find is they referred to the sociological evidence that Japanese Americans sent their children to Japanese schools. Some of them had dual citizenship, which of course at that time was not a choice that the children made, that they worshiped the Shinto religion, and on and on. They were these sociological half-truths, exaggerations, in order to create some rationale for imprisoning the Japanese Americans. One of them, too, was that the Japanese Americans may have been involved in signaling to Japanese vessels off the shore of the West Coast, a claim that we later find out was a complete lie and absolutely refuted by the Federal Communications Commission and the FBI. Nevertheless, the court makes this decision, and you could tell that it's a weak decision because it relies upon the dreaded double negative. It's the use of language that your English teacher would give you an F for, because it says, they talk about, we cannot reject as unfounded. We cannot say. That's like coming home on Valentine's Day and telling your significant other, honey, I cannot say I do not love you. It's a very weak way of expressing what should be an emphatic statement. Yasui was the case right after Hirabayashi, and rather than repeat what it said or wrote in Hirabayashi, pretty much was ditto. We agree with what happened in Yasui. A year and a half later, Fred's case gets called up. I mean, they had to split these cases up because of the issues. Yasui and Hirabayashi were an 8-0 decision on the Supreme Court. Fred's case was a little different. He challenged not both the exclusion from the West Coast, the banishment, the exile, but he also challenged his imprisonment, which the court refused to hear for procedural reasons. But the court opens with very magniloquent statements about the rights of Americans, and you could read this: the restrictions are immediately suspect. Only the gravest and imminent danger can justify such great deprivations. And you're thinking, okay, well, this is really good language. This is how the law should be. And yet the court ignores that and upholds Fred's conviction on the same basis as Gordon's conviction and Min's conviction. We have to defer to the judgment of the military authorities. And in that sense, it creates the worst and most dangerous precedent of all. And it's almost not the incarceration of the 120,000 people. It was of a certain race. It was the complete deference to the president. And that deference gets repeated, in decisions later on. And that decision creates one of the most dangerous precedents for the rule of law in this country, because it didn't require the president to show any evidence. It didn't require the president to prove up his claim that there was a military necessity. And in fact, just threw up their hands and they gave up and said, whatever you say, you're right. Well, we can't fight this. And after Korematsu, It was a 6-3 decision, though, and 3 dissenters issued blistering dissents. Justice Murphy talks about the ugly abyss of racism and dissenting from this legalization of racism. Justice Jackson, who later runs the Nuremberg hearings in Germany, a brilliant man, writes one of the most compelling, cogent dissents when he talks about the decision lies around like a loaded weapon. The principle lies around like a loaded weapon, ready for the hand of any authority who can put forward a claim of plausible claim of urgent need. And that idea of the loaded weapon becomes a theme when you see other institutions that adopt decisions or policies that come along later that could actually harm or threaten our democracy. There were 3 categories of misconduct. This was discovered 40 years later. A professor named Peter Irons had discovered in the archives all these documents of the Korematsu, Hirabayashi, and Yasui cases. They had never been opened. And the reason they hadn't been opened, he was doing a book on these cases, and they had misfiled them with the Immigration and Naturalization Service because Japanese were reclassified as American citizens to enemy aliens. So they, in effect, lost their citizenship just by fiat, and these documents then were untouched. And when Peter opened the first document, he saw a memo from some of the lawyers in the Department of Justice, the lawyers who were prosecuting the cases against these 3 men in the Supreme Court. And the memos were startling. They discussed and warned against misconduct. We found evidence absolutely contrary to what we're arguing in the Supreme Court. And I wrote these down to make it easier to understand. There are 3 categories of misconduct. One is the official reports, which disputed Japanese American disloyalty. A man named Lieutenant, what's his name? Kittle. He had researched Japanese Americans for 3 years prior to the war. And he was the preeminent expert on Japanese and Japanese Americans. He had concluded after much surveys and spending his whole time researching Japanese American that they were not more disloyal than any other group. And in fact, there should not be any attempt to incarcerate them or banish them en masse. And that report was sent to the Department of Justice, but was never shown to the Supreme Court, despite the lawyers suggesting that, or not suggesting, requiring them to send it to the Solicitor General, telling them, you've got to present this evidence. This is exonerating the Japanese American people who are essentially being tried. The second category of misconduct that Peter found was these reports. Again, like I mentioned, that Japanese and Japanese Americans were signaling to troops or to naval vessels off the coast of California. And when they were investigated by the FCC and the FBI, they discovered that every single one of those were untrue. And that what had happened is that the general on the West Coast, General DeWitt, who was a notorious racist, even said publicly things such as, a Jap is a Jap. No piece of paper like the Constitution is worth anything for them. And so his statements, by the way, which were unlike and very similar to President Trump's talk about Muslim Americans in the Muslim ban case of Trump versus Hawaii, very similar. And they were not entered into evidence, of course. But they found out every one of these incidents was untrue. And they tried to alert the authorities, the Solicitor General, that what we're doing is telling intentional lies. And I'll show you some of the documents later on. I'll rush through those because it does take a little while. So these reports were refuted, the claims by DeWitt, and the opinion by the FBI director, J. Edgar Hoover. I mean, this is like no friend of civil liberties. And yet he advised against incarcerating Japanese Americans. He said, paraphrasing, I have files on everybody. So I know the ones who are dangerous, and there are about 2,000 of them, and we could round them up just like that, which actually was done. But he was actually an opponent of the incarceration. Finally, the third category was an official report that was the justification by General DeWitt for his military orders to exclude and banish Japanese Americans and imprison them. And in his report, he says, look, we don't, it's not a matter of time. We have plenty of time to make decisions on who to imprison or not. It's a matter that it's impossible to tell the loyal from the disloyal. It was a revival of the old inscrutable argument that Asians, Orientals are inscrutable. So no matter what we do, we can't find out what's in their hearts or their minds. And so therefore it's fruitless. We can't separate, as he puts it in the report, the sheep from the goats. Well, that caught the attention of the people in DC, most notably John J. McCloy, who was Under Secretary of War, Deputy Secretary of War. And he said, we can't argue this. That's patently racist. Well, a big argument ensued, and finally they required the recall of all 10 copies of that, quote, final report, the justification, and they actually had them burned. And they were certificates of burning because they had changed the report to make it more palatable to the Supreme Court. So the report then read exactly the opposite. It wasn't that there was insufficient time, turned into there was insufficient time to do loyalty hearings like they had in Britain and France. So they changed that report, burned the original copies, but by accident, one copy remained. And a woman who was working with Peter Irons, just coincidentally in the archives, a woman named Aiko Yoshinaga Herzig, discovered that one copy, discovered that one change, and was able to provide that to us during our reopening of the case. Well, after what I am talking about, I guess, the evidence here, the official reports that were withheld, the Ringel report, all of these were ignored by the Solicitor General, and that the justifications by John DeWitt were not shown to the, except in revised form, to the Supreme Court. I think what is remarkable to me is that Peter discovered not just these problems, but he discovered the attorneys who felt constrained. They felt required to tell the Supreme Court of exculpatory evidence. They were rebuffed at every turn, but they sent memos. Edward Ennis, who later, ironically, became head of the ACLU, and John Burling, warned the Solicitor General about these acts of treason, which were not true. And he even says it's highly unfair to this racial minority that these lies, calls them lies, go uncorrected. Ennis and Burling sent another memo to the Solicitor General that this is an ethical problem. We have to advise the court of this contrary evidence, or it might approximate the suppression of evidence. And he calls it an ethical duty. Of course, the Solicitor General, John Fay, ignores them. And in fact, when we found a transcript in the Supreme Court where the court asked him, we're a little suspicious about some of this evidence, quote, evidence of the DeWitt report. And Fay says, I stand by every paragraph, sentence, and word that we have written in the brief. And those sentences, words, and paragraphs were outright lies that were contradicted by evidence that Ennis and Burling had discovered. So 40 years pass. Japanese Americans return to their homes. They try to rebuild their lives. They try to forget about the shame and guilt. My parents almost never talked about the incarceration for many, many years, 40 years. And I think they were greatly shamed and deeply saddened by what went on. We never knew the kind of hardships they went through, except the one time I remember talking to my mom, and we had reopened the cases, and we were talking about, I was trying to figure out where she went, and she was talking about living in horse stalls. And it was the only time I saw my mother cry. She just broke down and said, I think it was really, really bad, in her very understated way. Anyways, 3 men. These are the Quorum Novus petitioners. This is Gordon Hirabayashi, then became a professor in Calgary. Minya Sui became a civil rights leader. And Fred Korematsu continued his life as a tradesman, a draftsman. But they came together. We decided to reopen their cases, and we brought them in several different venues. But I think part of our mission was not just to exonerate these brave men who stood up. It was to correct the historical record, which was distorted completely by articles, people who ignore history, try to distort it, try to change it. We also wanted to put a nail in the coffin of Korematsu versus the United States, one of the most criticized decisions in American jurisprudence. We felt that we needed to damage this precedent because it was so damning for future generations and for constitutional law, for that matter. So part of our work in reopening these cases was to do education. And I should backtrack a little bit. I was a young lawyer then in Oakland, and I remember getting a call from this Peter Irons, the guy who found the evidence, along with Aiko Yoshinaga Herzig. Peter called me up and said, look, I got your name, because I had done a number of impact cases and in the past, and working with the Asian Law Caucus and other groups. And he said, I got your name from a couple of lawyers that I work with, including Minya Sui, one of the plaintiffs or petitioners. And I'm wondering if you would want to reopen the cases of these 3 men. And of course, my first question was, are they still alive? I mean, this is 40 years later. They were names in a case book. And like in law school, they're abstractions to you. They're arguments about collision of rights. They're arguments about statutory interpretation. So then to see these people in person, it was like meeting them in person. Famous names in a case book was like being in a room and Panoyer and Neff comes in and wants to talk to you about their case, or Mrs. Paulsgraf, whatever. It was daunting, in other words, to be a part of this endeavor. And then I asked him, how did you find them? He said, well, the phone book. And to younger audiences, I have to explain what that means, because with Google and with the internet now, folks don't, I have to explain what a mimeograph machine is. And that's part of that 50 years, Peter,
Yeah.
of being old. Anyway, so we reopened their cases, and we did it with a bang, with a press conference. This is our team with Fred. We did it with all 3 men at the initial press conference. And these are part of their teams. My now partner, or later partner, Don Tamaki, Dennis Ayashi, who's a Superior Court judge. This is Peter Irons. And this is Lorraine Bonai, who became a professor at Seattle University. She became my partner too, as we worked together. I told, part of the education was we needed to, tell the world about what really happened, and about this amazing discovery of a fraud on the Supreme Court. We've never found another case where a fraud was alleged on the Supreme Court, and that led to an overturning of these convictions or reversal of the case. We told Fred, who was a very shy man, that you don't have to do anything. We're going to make sure that we keep the reporters away, that you don't have to do anything, because he and his family were very private. And of course, we were lying, because we really needed his voice and his person to put a human face on this enterprise of reopening his cases, getting his conviction overturned. So we started out with a very sympathetic reporter, a Japanese American, low key. Then we escalated a little bit to a regional reporter. And then one day we got a call from Ed Bradley of 60 Minutes. He wants to do a story, it was actually premiered on 60 Minutes. And this is just kind of a funny picture we took, because we had discovered electronic games, and this one was Space Invaders. And this is again dating myself, but during breaks, this is a producer, and Ed Bradley got hooked on this game, and they just kept playing this game over and over, and then did the interview in between. As we filed in the early 1980s, and we had decided to file in 3 different venues, because then we had 3 chances to win. And you're supposed to do that anyways in coram nobis, which the name of the vehicle we used. Coram nobis, of course, we had to look up in the Black's Law Dictionary, because we didn't even know what it was. But it was really a variation of habeas corpus for a person to overturn their conviction if there's been manifest injustice or grave misconduct after a sentence has been served. We brought a case in the middle of a movement, a campaign by Japanese Americans, led by Japanese Americans, but joined by people of all color in this country, to gain redress and reparations for Japanese Americans. I mean, it's pretty timely to talk about this because of the calls for African American reparations. In any event, a commission was formed. They did a study, and during the middle of our case, they were starting to write their report, and we got wind of some of their conclusions, one of which was the broad historical causes that shaped the exclusion and detention were race prejudice, war hysteria, and a failure of political leadership. And that report, which became official, we had convinced the opposing counsel. It's kind of a trade-off. He didn't quite understand this was going to happen, but we asked him if he would accept judicial notice, which was the vehicle that was used to admit the DeWitt report in the original cases. We thought this would be historical symmetry. They got all this information or evidence in. Well, let's bring this, this salubrious or good evidence in as well, which he agreed to. And of course, you practitioners know in federal court that the judge you get randomly is going to be the one that could make or break a case. Our first choice was Judge Marilyn Hall Patel. We knew her from the Oakland Municipal Court. She was appointed by Jimmy Carter. And by coincidence, again, I had appeared in front of her on a number of criminal cases, motions to suppress, and I thought she was just wonderful. And so she was our first choice. And when we filed, they didn't know how to file coram nobis. And the chief clerk came out and said, wow, I haven't seen one of these in 30 years. How do we file it? Civil or criminal? And I immediately said civil. We should file this as a civil case because it's a hybrid type of action. And the reason you file for civil is obvious. You get discovery, and we get to do interrogatories. We get to do requests for admissions, depositions. We had a hearing, and the hearing essentially was to determine whether that the judge should make rulings on the facts and publish those rulings. The reason we needed those rulings was in coordination, semi-coordination, with the legislative efforts to gain redress and reparations the opponents in Congress were arguing that, wait a minute, didn't the Supreme Court already rule on these cases in 1943 and 44 against what you're arguing? And the response could not be strong, because it's true, they ruled against Korematsu and Hirabayashi and Yasui. So we needed some way to impact or impair those rulings. And to have a finding, a judicial declaration that impugned or impaired those findings would give our proponents some ammunition to fight against the opponents. So Judge Patel, on the day of the hearing, she moved it to a ceremonial courtroom. Probably 300 to 400 people were there. The jury box was filled with the press. They put in movable chairs. They packed the entire place. In fact, people were standing in the hallways because they didn't get there on time. And after argument, she asked for argument on what kind of decision she should make. I started the argument for Fred by saying, 40 years ago, Fred came into this courtroom in handcuffs. And for 40 years, we have not had the trial that Japanese Americans deserve. And so today we are seeking a measure of justice denied Japanese Americans some 40 years ago. Fred got up and gave a very nice statement, and I shouldn't say nice, a very significant statement of how he came here in handcuffs. And he's doing this not just for himself, but he wants to make sure this doesn't happen to any other American again. Well, we're prepared to have it submitted, but we're surprised by Judge Patel. She ruled from the bench. She had a prepared statement. So I guess my argument wasn't that persuasive, because it was pretty much already written. And she did say that the government deliberately omitted relevant information. And she said that the facts for military justifications were unsubstantiated and tainted with racism. Those are exactly the findings we needed. But she concluded with a statement that was both, I think, wise and prophetic about how our institutions must stand up against any assaults on a democracy or government actions, that the courts need to view with close scrutiny these kind of decisions. They cannot abdicate their role to be independent fact finders. And in this sense, the courts and the institutions need to protect the rights of the marginalized, the people who don't have that type of power that could make policy in Congress or influence with the president. And that's where the role of the courts has to be. Gordon's case took a long time. It went through he had to go through trial. The court split the baby on that, ruled in favor of him on one count, against him on another. He eventually went to the Ninth Circuit, and he was lucky enough to get Judge Mary Schroeder as one of the three panelists on the judge. And she wrote a similar decision to Judge Patel, who then overturned both convictions. Minya Sui's took a slightly different route. His judge just didn't want to hear it. Just said, okay, I agree with the prosecution. We're just going to overturn this conviction. We're vacating the conviction. We're not going to make any findings of fact. Whereas Hirabayashi and Korematsu, we needed those findings. So all three men won their cases. Unfortunately, Min died in the midst of his appeal. He wanted the findings of fact. Years later, not years later of our case, but in the interim between the case, the original cases in incarceration, in our case, Gerald Ford had repealed the executive or rescinded Executive Order 9066, the order that sent the Japanese to camps or the prisons, and recanted in terms of the justification. Eventually, acting Solicitor General Neo Katyal, a commentator, of course, and brilliant attorney, became the acting Solicitor General, and he issued a confession of error in May of 2011 saying, we misled the court, we lied. We undermine the legitimacy of the entire institution by doing this. And we should not make that mistake again. So that was a really strong position. Eventually, all three men not only won their cases, but got the Presidential Medal of Freedom. Unfortunately, Min and Gordon got theirs posthumously. Fred was there, and actually I was even there when he got it in the White House. And so, in a sense, they were exonerated, and especially by the 1988 decision signed by President Reagan, granting $20,000 in an apology to Japanese Americans who were incarcerated, and a civil liberties education program, which we dearly wanted as well. So all of the courts and the institutions came full circle in the sense of exonerating Japanese Americans and especially our petitioners. Well, we hear echoes of history, and this is one of them, where he says, okay, this was not working, but basically, this is before he becomes president. He requires, excuse me, let me go back here. He requires exclusions of Muslims, even though, his statements are blatantly racist and overgeneralized. I need to go on a little bit and run through these a little more, because what we're seeing again is, I don't have much time, but we're also seeing this assault on democracy. And it's something that is akin to what happened when hysteria overturns this country, because the rivers of racism run very deep. And at times of crisis, they overflow their banks. And the victims are marginalized people like my parents and my whole community. And in this case, it's going to be immigrants or Muslims or people of color. We talked about the replacement theory, and then we see the actual insurrection. We see a revisiting of that whole racist notion of calling the Kung Flu virus, which then leads to remarkable incidents of violence. Just 11,600 since the pandemic have occurred against Asian Americans. Usually 2/3 of them are women. And this repeat is very disturbing. It's the reason I don't like to go out anymore. And I don't think I'm alone. I think there's a lot of people who are afraid to leave their houses if they're Asian American because of what they've seen. So that's pretty much all I had. I think a couple conclusions from this. There are lessons from this, and some of the lessons are that our own institutions cannot protect us. They haven't then, and right now I was really becoming very skeptical and dismayed by the courts, and I still am by the Supreme Court. But I find that these other courts are doing their best to put obstacles in the way of a complete destruction of our democracy, the kind of barbarism that occurs against immigrants, and so I'm still hopeful that if we're not going to get a court ruling, we're not going to get something from the Senate right now. But I'm thinking that if people need to step up, and that's just to dissent when they believe they should dissent, because people like Fred and Min and Gordon, they were dissenters, and they were pariahs and ostracized within their own community in the 1940s, and today they're considered heroes. So dissent sometimes can be the highest form of patriotism. I think this incarceration brings in a focus lessons about that fragility of our civil rights, that vigilance is required. We need political power. We need leaders who will stand with us. And clearly justice is not self-executing. You can't depend on the government. That civil rights are not a gift. They're a challenge. And so I think the biggest lesson to me is about political power, because in 1942, Japanese Americans stood virtually alone. They had no allies, not one. Until the ACLU came in later. At first, they didn't even want to defend these cases. And there was a big fight within the ACLU. About the only national leader who stood up was Norman Thomas of the Socialists. But we were abandoned, our people were abandoned by every national group, not one. And so they stood virtually alone in 1942. But in 1988, when redress passed, a whole coalition, a rainbow coalition of people came together and mounted a massive political effort and achieved a monumental victory. So I think if we want to create that more tolerant, that rule of law, the kind of country that I think the Hellenic society speaks to, we have to act. We can't just be armchair radicals or slacktivists just signing petitions. I think we need to speak out. We need to remember the history, how we got to this moment. We've got to fight back because, again, democracy, civil rights, they're not a gift. They're a challenge for us all. So thanks. I'm done. I think. And thank you, Peter, for your kind invitation.
Dale, I want to thank you on behalf of the Hellenic Law Society for a remarkable career, a remarkable case, wonderful talk. If we can unmute, Stuart, can you unmute everybody? Maybe he's not on.
We could unmute ourselves.
We unmute ourselves. Please, let's give Dale a round of applause, and then we'll have a few questions.
Very good.
Can somebody stop the screen share? That would help too.
Oh, yeah, that's what I've got to do.
Yeah.
There we go.
There we go.
There we go. So, Dale, give us a little bit more about Peter Irons contacting you and how you got started. And I want to put it in the perspective of, the judiciary is sort of the closest to true democracy in the sense that individuals can present their own case with a lawyer, and it takes a skillful lawyer to do this kind of work. But can you give us a little bit more about how you got started in this effort and some of that?
I had graduated law school, and I fell in with the wrong crowd, a group who wanted to create a community interest law firm. It's a public interest law firm to serve the Asian Pacific American people who were pretty much overlooked and invisible. And so we started a group called the Asian Law Caucus. And from there, our ideal was to do impact cases to affect the larger educational and political power of this Asian Pacific Islander community. So as a result, we sued a lot of people, some successful, some not. And so we then opened our own firm, a private firm, which we went from a nonprofit community interest firm to a nonprofit private practice, which was, of course, not intentional at all. But we kept on doing pro bono work or public interest work because we felt that was part of our mission in law. And so that's pretty much how Peter got my name, through some of the other older attorneys who were involved in a lot of activism earlier on. And we had some other friends who helped us out. Ken Kawaichi, who became a Superior Court judge, Joe Morizumi. But mostly we were a group of young, fearless, pretty ignorant, naive young people who thought we could change the world. And of course, it's a lot harder to change the world in the real world. So Peter, like I said, he called me up and told me he had these cases. And I was astounded because, you know, I had read Korematsu versus the United States in law school, and I thought it was bunk. I couldn't believe the kind of arguments, and if you read it closely, they're illogical. They evade the real issues. They say things like, you know, Korematsu was not excluded from the military area because of hostility to him or his race. Well, that's actually absolutely BS. There's the whole reason he was excluded. But the problem with the Supreme Court could not, they did not have evidence. So they had to make some of these idiotic statements in order to justify what they're doing. So later on, I had worked with a professor at Berkeley. I volunteered on a project about reopening these cases. And he said, no, we're already full up. We don't need any help, and we can't, it's not going to be successful anyways. So nobody ever thought these cases could ever be brought up again. In fact, we had some research done on the whole issue of reparations. We looked at Germany, we looked at other countries as models. But it was my thought that for reparations to, and that's my conclusion, to be successful, it had to be fought in the wide open corridors of Congress rather than in a small courthouse. So I had been interested in this issue for a long time. And so when Peter brought this up, I was, one, astounded at the evidence he produced. And I asked him, I was skeptical. So I asked him to send it to us. One thing that saved him was that he was a tenured professor of political science. He was also a lawyer. Graduated from Harvard, that school back east somewhere, and he sent us the information. And the first documents that he saw that blew his mind were the same ones that we looked at, where the attorneys are saying we are lying to the Supreme Court. And you know, how often in your life do you get smoking guns? I mean, it was like incredible. It was almost unbelievable. So we had kind of the confidence of fools, maybe, but we knew that the evidence was very, very strong. And we also knew that we had to get a good, sympathetic judge. So we had to essentially luck out. And in fact, when we went to file the petitions for Fred Korematsu, we were going across the Bay Bridge. I lived in Oakland at the time. And we got in the shortest line at the toll plaza. And it took the longest time. It was like somebody was paying in pennies. And Peter goes, God, I just have this bad luck too. I never win anything in bingo or raffles. And so we turned to our associate, Lori Banai, who's had her share of luck, good and bad, but fairly dramatic. We said, Lori, you got to file these for us. So she carried this huge stack. And she knew what was at stake. She knew that we needed a judge. She filed the papers, and the clerks, who also know on civil rights cases who the good judges are, turns around and smiles and says, you got Marilyn Hall Patel. And so we were slapping high fives in the clerk's office very ungracefully and with impropriety. But we knew we had a good chance. At that point, we knew we had a really good chance to win the cases.
Dale, thank you for joining us. It's really important. Your presentation and your story is really important. And I think we all know that there's a new generation of lawyers and others who need to know this story. And I had to share that, you know, I'm sure I grew up in San Francisco public schools, and I don't know when I heard about this, but I remember taking a pre-law class out at San Francisco State, and one of the assigned readings was the Eugene Rostow law review article.
Yes.
From Yale, right?
Right, absolutely.
This transformed my life. This,
Well,
in a
it's
certain
interesting.
way, really transformed my life. And it's to have the truth revealed. And it's like what your suit and what your action was doing, to have the truth revealed. It can be so powerful. But I remember that distinctly, that was a changing moment for me in a certain way, as far as my perception of, you know, trying to the government and the government's conduct, and even, you know, hey, here's something from the Supreme Court of the United States. Well, you know, turn over the rock, you know, turn over the rock and try to find out what's really going on. But thank you. And I want to, however much energy you have, I want to try to have you present in different forums as well, because I think it's really, really important.
That article you mentioned, by the way, I'm glad you mentioned it, because that was the seminal critique. And it was done only 6 months after the Korematsu decision came down. Eugene Rostow was the dean of the Yale Law School, and he wrote a scathing critique, and he pinpointed all the weaknesses in the government's case. And those very weaknesses are the same ones that eventually we found evidence to support. And he criticized the court for the same reason we did. And so that article is just absolutely brilliant and prescient, because it did foretell the kind of arguments we were going to make.
Other questions?
Well, you know, I wanted to ask, was you bring this action, is there any opposition? Is who are you? Are you arguing against anybody, or are you just trying to convince the court?
Well, no, the opposition was interesting, because I think there were hawks and there were doves in the Department of Justice. Some who wanted to fight it, which they did in Hirabashi. They fought it tooth and nail. But we went first in Korematsu. And I think they were trying to decide whether to concede, how to concede. Do we preserve the institution of the Department of Justice? Do we demonize a Democrat? Because this was a Republican administration now. Do we demonize a Democrat and give up? They couldn't come to a decision. I think it was too difficult for them. It was too monumental, both as an issue, both societally, politically, and legally, to come to a real clear conclusion. I think if they would have conceded early on, that they would have not had the problems they would have had. In fact, Judge Patel was really getting irritated at them, and so she was pushing them along to file some kind of response, and that's how we were able to get the they call it the Commission on Wartime Relocation and Internment Report, because it's called Justice Denied. Well, that kind of gives you an idea how how it's going to read and how it's going to go. And we knew it was going that way, because one of the researchers who found the DeWitt change, Aiko Yoshinaga Herzig, just beautiful, cute lady, about 5 foot tall, gray hair, looks like your grandmother, kind of, or my grandmother anyways, totally seeming inoffensive, was actually our mole. She was kind of a spy for us. And she was hired by the commission to find documents. Well, she's hired by the government to find these documents, and she's sliding them over to us. So we have more ammunition in these cases. And I had known her for years, but I didn't realize that she was that good of a double agent.
Dale, since this is going to give us like 1 unit of ethics credit, what about the Supreme Court? You said that the Solicitor General, a subsequent Solicitor General, had made a statement that they were in error and they did something wrong, and apologized, I guess, is maybe is perhaps the right word. But what about the Supreme Court? I mean, they have a job of rooting out when the facts are missing and what the actual facts are when they shape their decision. Has there been anybody other than the 2 justices after they retired that admitted that they got this wrong and that the institution needs to do a better job?
You know, the justices didn't know because they were blindsided. They were not given the evidence. Although, you know, there's some indication that Felix Frankfurter had some inside information. He was a real slick guy. And even in his autobiography, they're talking about he and John J. McCloy were really close friends. They would meet for lunch almost every week. And John J. McCloy was one of the prime suspects in manipulating this whole set of cases. So my guess is Frankfurter knew what was going on, and but it was never quite proven. So the justices as a whole didn't know, but they suspected that the evidence was not there. And if you look at people like or dissenters like all the dissents, they're saying, how can we believe these self-serving statements by this military commander? Where is the evidence? And the dissents really narrow our focus on the issues, but they don't. I don't think they bring up the ethical issues as much. Now, Lori Bonai, like Chris knows, my partner and then one of the lawyers on our case, has written a whole set of modules about the Supreme Court and the ethics issue of that Supreme Court. I should have sent that to you, which I still can. But she has continued what we had failed to do after the Korematsu and Hirabayashi cases. We were just really tired. We were also broke because we didn't get paid for any of this. It's all pro bono. But Lori has kind of kept on being a professor. She's really pushed constitutional law to teachers to teach her module, to teach something about the Quorum Novus cases, but not only as a failure of the Supreme Court by not using the tool of strict scrutiny, which they said they would, but also about the ethics of the lawyers involved. So she has a whole module on the ethics part of it, and it had to do with part of the biggest ethical violations was John Fay, the Solicitor General, the one who just bald-faced lied to the Supreme Court that we have no evidence contrary to anything we're saying here about the disloyalty of Japanese Americans, about their danger to this country. He knew that that was not true, and yet he just straight-faced said the opposite. So this was before Brady versus Maryland, the codified duty, or the duty to provide exonerating evidence, but it still falls within due process. It still falls within the ambit of a law that you don't cheat in court, you don't lie to people in court, and so that became one of the issues. What law and what standards do we apply? I mean, we had to rely on the ancient documents doctrine, which I hadn't studied since law school. I didn't have a case with ancient documents. I mean, there were a number of those evidentiary issues that we had researched because we were afraid that we could get caught in a trap, and it would be easily, well, maybe not easily, but it would be procedurally possible for a court to just throw us out on some of these issues about, well, what was the law like in 1944? I mean, can you say that this was applicable today in 1983? And so we did have some of those kind of issues. Fortunately, again, it was more of a civil type case, so laches was a big issue, but it was not a big issue because we had just recently found the documents. They were hidden for 40 years. And so we didn't have the statute of limitations or laches or anything like that as an issue. But there were quite a few other hurdles legally.
When you're talking about historic law and what was the law, you just sort of reminded me, and I will confess I haven't read all of Roe versus Wade, but I've read news articles about it, and you have the Supreme Court talking about what was the law like in 1787 or 1787, and what was the law like in 1869 or whenever those other amendments were passed. And I'm showing my failing memory of of the 13th Amendment or the 14th Amendment. Professor Panos, you know what the amendment, no? But there we have the Supreme Court making all of these findings and using it as a rationale for their decision. And you know, where are they getting all of this historic evidence from, and et cetera? So
Yeah, I think for them to do psychiatric or psychological excavations of what the founders believed as a justification is bunk. I mean, this is why the Supreme Court has lost so much credibility. And, you know, people, they try to put on the facade that this is not a political body. And it has always been a political body in some ways. And sometimes it's done really good things and sometimes bad things. But, you know, I don't think this whole facade or charade of, you know, the politics is not an issue. We call balls and strikes. No, I don't think so. And even if you did, I mean, these strike zones today, if you follow baseball, are being highly contested. What kind of zones, and why don't they use robots now? Because, you know, balls and strikes is discretionary, just like, you know, the Supreme Court decisions. So I'm very disappointed with this Supreme Court. I really think they should expand it. And I think they should have term limits, or they should figure some way. And I'm not just saying that just because it's my ox is being gored. I think that, you know, to put somebody in that position, and especially, I guess, the biggest issue with the originalists, for them to claim that they can apply concepts that did not even exist in the 1700s, like the internet. How are they going to figure out how to make, or Facebook, or, you know, Google? How do they figure out that that's applicable and they could derive, you know, wise principles from situations where we didn't even have cars, we didn't have planes? I mean, it's ludicrous to me.
You know, Pete, it might be a nice topic for a future roundtable.
That's a good one, yeah.
Because originalism has actually, it has now emerged as this respectable theory in many quarters, when only 20 years ago it was just a total fringe idea, accepted by very, very few, except the most extreme. So it might be interesting to have a presentation so we could all learn more about it, and, you know, different judicial philosophies.
we did a talk 5 or 6 years ago on the Second Amendment. And what was startling about that talk is, you know, it was 200 and some years before the Supreme Court issued a decision under the Second Amendment. And Justice Scalia who said that the Second Amendment prohibited this Washington, D.C. from having a handgun prohibition because of all the murders in Washington, D.C. And it's just fascinating. I mean, there's this amendment that's been around since, what, 1787, 1790, whatever those first amendments were. Yeah, that's a great topic, originalism. Are you going to teach that one, Chris?
No, but we should get a couple of people to it would be nice to get a couple of people to make the presentation. Let's hear from somebody who embraces the originalist view, and have somebody who critiques it. I think that'd be great.
The business law section today actually had an argument by Chemerinsky regarding the choice decision, and he went into great detail on the history, like he can, without looking at one note. Dean Chemerinsky can just go through absolutely. I mean, it's just brilliant, his analysis, but he completely said, and he's coming out with a new book next week, in which he actually said, this is what they're going to do. We can
Wow.
see that that's exactly
Yeah.
what they're going to do in overturning Roe v. Wade, despite all precedent with Casey and everything else. So it was quite interesting.
Thank you, Madam Mayor. Are you still the mayor?
Now I'm the vice mayor. Give me till December, I'll be the mayor again.
Okay, the rest of you haven't asked any questions, and Chris and I have been carrying the ball. So who else has a question for Dale? What kind of lawyers are you? Okay, well, if we don't have any further questions, let's give Dale another round of applause. And we'll hope to see you maybe the next time we go to Kopari. You have to come as our guest, Dale.
Yeah, thanks, Pete.
Okay.
Hey, Peter,
you.
actually, I just did think of a question I'd like to ask, if I may.
Of course.
Thank you. Dale, was there any, in this whole process, starting from when your parents and others were incarcerated up through your appeal process, were there arguments made about why Germans and Italians weren't similarly incarcerated?
The arguments were made all the time because some of the sociological facts that were pointed to in Korematsu about, having their parents have their kids go to language schools and other things were raised often. And I'm glad you brought that up, because one of the irrefutable, I feel, evidence of why racism propelled this whole tragic episode was that Hawaii, Japanese Americans in Hawaii were not incarcerated en masse. That was the site of Pearl Harbor. It was the site of the locus of our Pacific Naval Fleet. It was a place where the largest concentration and number of Japanese Americans lived, and yet they were not taken away. And it's an interesting story because a guy named Tom Kaufman has just published a book about that, and how the Hawaiian, some citizens there grouped together to forestall any kind of incarceration. And yet in California, for example, the Growers Association wanted to get rid of the Japanese because they were taking over so much of the land for agriculture, or they were so successful, I should say. And so, and the politics were different too. There was not I think it was a gubernatorial election where Earl Warren stood up and, criticized Japanese Americans. So that issue has come up again, and another point to be made about why racism was the genesis of this whole incarceration. Now, some Germans and Italians did get individual hearings. Some were citizens, and some aliens were incarcerated because they were probably on J. Edgar Hoover's list. But other Japanese Americans didn't have the same luxury or were afforded hearings that they should have had.
How did the Supreme Court back then address that issue? I'm sure it was raised that there was a lack of equal, application of the law.
They did not. Again, if you read those decisions, you're going to find enormous gaps. And it's unavoidable because there was no evidence, and it was racist, and they had to support the government at the time. That's why in Hirabayashi in 1943, when it was decided, even though the war had turned by then on the Pacific coast, or in the Pacific, Hirabayashi was an 8-0 decision. I think the justices, my theory, had to support the war effort. They had to show their unanimity in the face of an existential crisis. But in 1944, by then, the Battle of Midway was fought. The Americans were on the ascendant, and the Japanese were really on the defensive. And so when Korematsu was decided, there was now less of an incentive or motivation to create a kind of unity to bring the country together to defeat the enemy in the Pacific. I believe that's part of the calculus of the three dissenters.
Great, thank you.
Okay, well, Dale, thank you so much again. All of you should have received your MCLE paperwork. There's one page you sign and keep for yourself. There's a page that you need to sign and send in to me. And Stuart, if you're still on, can you take a picture, or Nick knows how to do this, of everyone while we still have everybody on? Can you do that, Nick? You're on mute, Nick.
Sure, I'll do that. I'll be happy to.
And thank you so much. Wonderful evening to everybody. And we'll see you on the next one in a couple months, maybe.
And my apologies for missing all the content, but thank you.
Thanks, Dale.
All
Thank
right.
you, Dale.
Thanks,
Thank you,
Dale.
Dale.
Thank you, folks. Appreciate it.
Thanks very much.
Bye-bye.
Keep
Bye.
up the good fight.
All right.